Hi, my name's Wonu Sanda. I'm a senior associate at CM Murray, and I'm joined by Sarah Chilton, a partner at CM Murray. We are going to talk on this 10-minute talk today about maternity rights and common issues within partnerships. We just thought it was an interesting topic, doesn't often get covered specifically for partners. So we thought it would be good just to have a general casual chat about the sorts of rights and the sorts of questions that we get asked by partners who are taking maternity leave or want to take maternity leave. So I think the first thing that comes to mind for me around this is, are partners the same as employees? Why are we talking about this? Surely they just get the same rights as employees. So we can end this here.
Because they don't, right? I
They
think that's the
don't.
thing that a lot of people don't realize is that as an individual partner taking maternity leave, although in most industries and firms, professional services, most partners are entitled to broadly similar things to employees, because most
Mm.
firms recognize that if they start telling the partners they need to be back in 2 weeks, they're probably not coming back in most cases, let's be honest. But actually, the legal entitlement is pretty much non-existent. So legally, a partner is entitled to 2 weeks maternity leave if they're a sort of true
I,
self-employed
I wanted
LLP
to
member.
stop there, just be like, I mean, if anyone from like the government or anybody that deals with legislation is looking at this, that's not okay.
No, it's
2 weeks,
not
I
okay.
don't think is a long enough time.
I mean, it's basic, right? Isn't it? So, um, it is quite odd when you think about it. Like that's all you're actually entitled to. In reality, though, most LLP agreements will provide for contractual entitlement to more than that, and
Yeah.
even in the back of that, a lot of firms are generally quite flexible about leave. So even if the LLP agreements it might say minimum entitlement is 6 months or 9 months, often what happens in practice is that someone going on maternity leave can usually take up to a year in the same way that an employee would be able to take up to a year. Because, let's be honest, if you were a firm that decided to insist upon 2 weeks, you wouldn't have any female partners probably in your partnership, or at least very,
I
very
mean, you might
few.
not anyway.
Yeah.
They might not at the moment.
Well,
I think
exactly,
that
because
tends to be a big issue, actually, is the reason why there's no provision for it in a lot of LLP agreements, because they hadn't historically had any female partners
yeah.
to have to give maternity leave, and then they have one female partner, first person who has to take maternity leave, and they're like, oh, never really thought about this.
Yeah. Now we need to write it into our documentation.
Yeah.
Actually, a lot of firms now that we either we advise individuals or firms, a lot of them now do have proper, appropriate maternity leave. Um, what follows on from that, though, is an interesting point also, and if you're a partner who's been on maternity leave, you will know this, but is the right to pay. So obviously,
Mm.
employees have got very stipulated, protected rights to pay on maternity leave. Not necessarily a lot of pay in terms of minimum rights, but certainly some pay, and for a particular duration of the maternity leave. And partners don't have that. So partners, LLP members don't have that. Again, most firms do pay something, but that will depend upon the size of the firm, the affordability, the nature of the work they do, the sector that they're in. Because there is no minimum right to maternity pay. But partners going on maternity leave are entitled to the very generous government maternity allowance. A little quirk about that: if you're a partner about to go on maternity leave, you can, I think there's two levels of maternity allowance. So you can be on the low level because you haven't topped up your national insurance contributions, or you can earn yourselves a nice sort of £100 extra a week or whatever it might be, which appreciate is still not adequate. The UK as a general point probably needs to address its maternity leave and pay requirements, but yeah, by adding sort of topping up your national insurance contributions, and that's also a slight quirk as to how partners are paid, because obviously they pay their tax on a delayed kind of arrangement, so they won't have necessarily paid the right level of national insurance contributions for the relevant period to entitle them to that higher allowance. So yeah, it's quite an interesting one.
Mm.
Maybe not that interesting for everyone, but
Yeah, interesting. Probably worthwhile saying though, for bigger firms where potentially there are individuals who are called partners or LLP members, but they're actually not,
yes,
and they might fall under the salaried members rules, so that they are in fact considered employees. And in that case, they potentially might be entitled to
yeah,
employee maternity rights and protections. So worthwhile thinking about, but for the majority of genuine kind of partners and LP members, as you say, it's it's the 2 weeks after pregnancy, after childbirth.
Yeah.
And the maternity allowance.
I'd say legally the more interesting thing to think about, but also if you're a partner who's on maternity leave, the things that we would normally get involved with are not to do with like basic levels of pay and entitlement, because essentially it's set out in your LLP agreement, you sign up to it, it is what it is. But it's where, and we see this a lot, is where partners might go on maternity leave, and it's often on the return from maternity leave that they might question whether or not they've suffered some sort of discrimination or kind of unfavourable treatment because of their leave. And that again is different to the employee position in terms of the sort of duration of that protection that they get, but also then the types of how you'd formulate the legal claims that partner may have in respect of maternity leave differ as well. In summary, we talk about this protected period whereby you can bring a claim based on the fact that you're pregnant or on maternity leave and have suffered unfavourable treatment. So you don't have to compare yourself to someone who's not on leave. You just have to say it's not good treatment, essentially. That's not a legal definition. And then that period is essentially 2 weeks, as Wonu says, the 2 weeks after childbirth. But it was extended. So from January 2024, it also covers discrimination that takes place after the protected period that relates back to the pregnancy or pregnancy illness. So it is broader now than it used to be. What sort of treatment, Wonu, are we talking about, though, just to put a bit of a real world spin on?
Put some skin on the bones. You just got back from having your baby. It's 2 weeks. You're fresh. Baby's fresh. And all of a sudden you're up for expulsion. They have said, we're looking at who we're letting go, and we are going to exit you, and we're going to terminate you under the provisions of the deed of the LLP agreement. That might be one thing. That's quite extreme, probably. We're talking about the extreme end. But then you've got de-equitisation. You're no longer meeting the requirements of partner. We cannot sustain your number of points, or you're standing in the equity. So if you want to stay, great, but we're going to bring you down. Or we're going to take away equity entirely, and you're just going to be, I don't know, insert title here, but not a partner. Taking work away from you when you come back, because they assume maybe about they make assumptions about what you're able to do or what you're willing to do without actually consulting with you. Decreasing your profit share. So next time that the profit share is up for review, again, it could be any excuse that's used. It might be a completely fabricated excuse, but it is obvious that it's somehow related to the fact that you had taken leave, maternity leave, or the fact that you had been pregnant. Or maybe they might think this person's going to be on and off, having childcare difficulties for the next year or two. We're not prepared to be flexible about that, so let's just dock their points now and not deal with it. So that could be an issue. There could be unfair criticisms in the performance process generally, around maybe availability or standard of work. Again, it might not be genuine. It could be linked to the pregnant period of the protected period whilst you were pregnant and the 2 weeks afterwards. If you had any pregnancy sickness, and not just morning sickness, any type of kind of sickness related to your pregnancy as well, it could be that you are subject to treatment because of that. So if you had some more absences than you might otherwise have, and it sort of triggered management to look into the fact that your billings and your time recording isn't what it should have been, that again could be unfavourable treatment, and it relates back to the fact of your pregnancy or pregnancy illness. So I think all of those things can happen, and it's not unusual. It's definitely not unusual when you're looking at the financials for a partner to say, I was on maternity leave and then I came back, and all of a sudden all these big changes were being proposed, and reasons to drop my equity points, or reasons not to acknowledge contributions, and again that can reflect financially as well. I think it's probably also worthwhile saying that the changes that you mentioned around the extension of the protection applying after the protected period now, if it relates back to the pregnancy itself, there's also been additional changes which will be helpful for LLP members, where they have some sort of contractual maternity leave. So like the ones that you mentioned where you said, you look at your deed, look at your partnership agreement, and see how much you might be entitled to. It could be the equivalent of what's been offered to employees. And if it is the equivalent, there is now references in the legislation that says that you have a right not to be untreated unfavourably because you exercised your right to take the compulsory maternity leave that you were given contractually. So that does equalise it a little bit more, depending on if you've even got the right in your LLP agreement in the first place. And equally, if you were seeking to exercise that right and there was some, resistance to that, if you were treated unfavourably, if they said, oh, yeah, I know we put it in the LLP agreement, but we never actually thought anybody would ask for it. And then all of a sudden you ask for it, they reluctantly give it. And then you come back and you start being subjected to some of this unfavourable treatment. Again, that could be linked back to you seeking to rely on your contractual rights, which are equivalent to, not necessarily in time, but equivalent in nature to statutory maternity leave, and you would have similar protections in terms of not being unfavourably treated. So worthwhile knowing that that's slightly been bolstered after the 1st of January 2024. So any unfavourable treatment from then onwards would be covered.
And it's worth saying as well that in practice, a lot of these cases might also look at sex discrimination. So whether that's direct or indirect sex discrimination. So it isn't the case that you can only rely on the specific maternity provisions of the Equality Act. There are general sex discrimination provisions, which we often see people returning from maternity leave, even years subsequently, relying upon in respect of any issues in partnerships in the workplace. Which sort of brings me on to, I think, one of the main things we see as a challenge where people are returning from maternity leave is around the slightly less obvious or direct consequence of that. So if you think about a professional services firm, for example, a partner, often in many firms, a partner's remuneration will be quite often linked to the remuneration that they bring into the business via their clients. If someone goes on maternity leave, they obviously have to have those clients serviced by someone else. And it can be, in some places, it's really hard for someone coming back to then get those clients back. Sometimes they're not willingly returned. Sometimes there's no support put in place for the returner to enable them to build back up their practice, which has a direct impact often on their earnings. So the firm might think they're applying a very neutral set of criteria to profit share allocation, for example, but actually that criteria has a massive detrimental, disproportionate impact on women who've returned from maternity leave, 1, 2, even maybe 3 years after they've come back. And so firms just need to be aware of that. And also if you're returning from mat leave or you've returned and you're finding that as a challenge, be aware that might be something that is actually unlawful. There is potential discrimination there in some cases. But I think that's sometimes the bit that gets missed or the bit that gets forgotten about is the sort of longer term impact of that time out. Obviously, if all women were just taking that 2-week protected period, then that impact would be much lessened because there would be it would be no more impactful than a holiday. I mean, it's I know each to their own, but the idea of 2 weeks to me is quite radical, not in a good way.
So if they, as part of the sort of performance metrics and assessment, not remembering to think, right, has there been an impact because this person's been on maternity leave, and not just in the period, as you say, but there is going to be a period of when you return that you need time to kind of ramp back up, build back up your practice, be reintroduced to your clients and start to reconnect with them, etc. And that all takes time. It's like having a lateral partner join, right? You don't straight away say, right, we expect you day one, everything in the door. It's not going to happen. So and that is a key risk area, I think, for firms.
It's a good analogy, actually.
Thanks. And a good way for for partners as well to challenge. And I think that brings us on actually to, probably we're going to wrap this up, but brings us on to what's actually good practice for firms when dealing with a partner who's going on maternity leave and also when they return. And I think one of the key things also for just retaining partners within the partnership and female partners within the partnership is coaching and training, both before they leave and when they return, to be able to encourage them to build back up their practice, but also give them the support to do that. It's a huge life event. And so, you are going to need some help when you come back to be able to, build back up, also understand what's changed in our area of law. For example, 1 year is a lot of time.
It's a long time.
So there's that. Is there a simple thing you can do, like implement some training? What's changed in the firm? Culturally, the firm, things are always changing, things are being done in a different way. You might have got some new systems in place. Don't just expect that someone's going to come back to their desk and, just leave it to them to get on with it. They might want to do that, but maybe engage and see that, is there someone in the team who can just sit down with you for the day or half the day and let you know, right, these are all the new things that we've done now. These are the key updates that have happened in the last 6 months or whatever. Allowing for the ramp up and ramp down on both ends of work as well. And again, not letting that adversely affect performance assessments. Maybe being proactive about flexible working as well, having those conversations early when the partner's returning, and making sure again that it's not impacting the way that they are being assessed. So it's not that, right, someone's come back, of course they've got now some childcare responsibilities, maybe the way that their family setup is now quite different. Having that in mind and saying, well, what can we do to support this individual? I think for me, the coaching, the sort of having someone alongside, whether or not that person's ever gone on maternity leave themselves or ever had a baby or has a family, I don't think it really makes much. Well, it might make a bit of a difference for connecting with an individual, but in terms of showing that the firm is giving some support, and if the firm has given some thought to what that support looks like, that's a step in the right direction. But I'm sure, Sarah, you've also got loads of other things to add as well.
No, I mean, I think the main thing is just actually thinking about it. So I think that's where firms will fall down, is that they don't really sit down and think about the impact that period of leave and subsequent kind of issues that we know are indirect sex discrimination issues, like part-time working, childcare responsibilities, etc. And really just thinking about the impact that has and trying to mitigate that as much as possible in providing support, but also then when you do assessments and look at that sort of aspect of that person's relationship with the firm. So no, I agree with everything you said. I mean, there's loads of things that you can do and loads of creative things being done out there, which is amazing. But we don't really have time to keep going and talk about them all. We could probably do that for a very long time. So I think that does bring us to a close. But yeah, thanks, Wonu, for all those thoughts. We hope this has been a helpful discussion, whether you're a firm or you're an individual kind of facing these issues. Hopefully something has sparked something useful and interesting. And if you have any questions or need any support with it, then obviously do get in touch.